Hi, everyone. Thank you so much for joining in for our very first webinar. As you're aware, the topic of this webinar is ownership of copyright for content created by AI. So how we'll structure this webinar is that we'll start discussing certain important questions with our panelists, and then towards the end, we will open the floor for question and answers. I will be moderating this webinar, and before I invite our guests, let me introduce myself. I am Tushar Bhargav, co-founder of Mike Legal. We at Mike Legal have been working with more than 250 law firms and corporates, helping them automate their trademark and contract proofreading and reviewing processes. So let us start with our webinar. Without wasting any more time, let me introduce to you to our panelists. Joining us first, we have Mr. Hemant Thadani, who is an associate partner at Crawford Bailey & Co. Hemant is an advocate and a registered patent attorney. He heads the intellectual property practice of Crawford Bailey & Co. And he also advises people and handles the entire spectrum of IP issues, both contentious and non-contentious, across a wide range of business sectors such as technology, pharmaceutical, and FMCG. He is credited to have handled a number of landmark litigations in IP, including in trademarks and design. So thank you, Hemant, for joining in.
Many thanks, Tushar. Thank you for inviting me over. It's a great pleasure to be here today and speak on a very new topic that is doing the rounds of discussion across the world. So thank you once again.
You're welcome. Our second panelist is Mr. Shailendra Bhandare, who is the partner in Intellectual Property Practice Group at Khaitan & Co. Shailendra's expertise in IP extends to the entire life cycle of IP, that is prosecutions, enforcements, contentious matters, management, and even transactional work, which includes IP due diligences, IP commercialization contracts, software contracts, and technology transfers. Hi, Shailendra. Welcome to our webinar, and thank you so much for joining in as well.
Thanks, Tushar, and thanks for having Hemant also here. Hemant happens to be a good friend of mine, so I think a good panel to have.
Nice to have this small reunion for this important topic. Great. So, before we begin, I'll just quickly introduce about the topic, and then, we'll dive into the questions that we have for you guys. Lately we all are hearing a lot about ChatGPT, and with the introduction of ChatGPT, everyone has been talking about the power of AI and the impact it can bring into our everyday activities. But not often do we realize that we already were using AI at so many different levels and so many different tasks that we were doing on a day-to-day basis. One such example is Google Photos. Whenever we upload any photos to Google Photos, it automatically identifies different people through facial recognition technology. Or even say we all are using all these multiple OTT and music streaming platforms. Even they are using AI to an extent because they detect our previous usage history, and on the basis of it, they are continuously telling us that, this is what we might be interested in. So, if you'll see, more or less everywhere we are seeing AI being used. And now these days, with so many AI tools are also coming in the market, the current trend is that people have started leveraging AI to create content. Now, this content could be around creating a marketing post, or it could even be to create an art. But now people have started acknowledging that, okay, this is something that we can use to simplify our tasks. So this is where my first question is to, both of you, that as per copyright laws of India, who is actually the author of work created by these AI-powered tools? So Hemant, would you want to pick this first?
Yep. Sure, I will do that. So essentially, before I jump into who the author is, what sort of work generally is protected under the copyright? So briefly speaking, there are different types of works which will fall into different baskets under the copyright law. You have a literary work, you have a dramatic work, then you have an artistic work, then you have a cinematograph film or a sound recording. So these are generally the subdomains under the copyright law where a definition of work could fall into. Now, as far as authorship is concerned, that authorship is defined in one of the sections, that is section 2, subsection D of the Copyright Act. Now, for each of the work that I just mentioned, the author could be authorship is defined in that. So, for example, if it's a literary or a dramatic work, the author is the author of the work itself. So, but for example, in respect of a musical work, the author is the composer. Now, when it comes to a cinematograph film or a sound recording, it would be the producer. Then you have the last, that is not the least, but which is basically what we are concerned today, is the computer generated work, which generates a literary work or dramatic work or a musical work. So that computer generated work is the author of that work is the person who causes the work to be created. So that is essentially the definition that is there in the act. Now, who is the owner of the copyright is actually defined in section 17 of the act, which says that the first owner of the work is the author of the work. Now, then, as I mentioned, the author is particularly defined in section 2D. And as far as the computer generated work is concerned, it is the person who causes the work to be generated. So by plain and simple meaning, it is the person who is causing the work to be created is the author.
Understood. Shailendra, you have anything to add?
No, I quite concur with whatever Hemant said, but I think there has been a slight. I'm a traditionalist when it comes to these laws, and I quite concur with Hemant on this aspect. But I think things have taken a change after Mr. Ankit Sahni got the registration for his a certain painting, which included as the co-author as the app itself. Now that has actually created a big furor within the fraternity as well. As to, of course, there's a lot of cheer also for it, that okay, it is futuristic, but the case laws and the jurisprudence which we have, especially Delhi High Court decisions which are there, which they clearly say that the natural person has to be the author of the work. So a lot of chatter around ChatGPT, as you would have also looked at it and hashtagged about it on the post which you had. When you look at the terms of use for ChatGPT also, it specifically starts off by saying that please verify that you're a human before you get into it. Second thing which you see in the terms of use is that all the contractual elements are necessary. You have to be 18 years of age, so on and so forth. So even to get into ChatGPT, which would otherwise be the flag bearer that okay, probably AI also needs to be the author of the work. At the back end, it is somewhere also demanding that the author has to be the human element.
Correct. And they've also put the ownership that, you are responsible for whatever content that we have created. You are liable to check the validity, whether it is legally done or not.
Funny part. They are making you the owner. And in fact, for the output that is being generated, for that also they are assigning you the work. So ultimately, the burden of liability is shifting from ChatGPT to the user who is using these services.
Correct. But lately you would have seen that in the US, there are sudden increase in the litigation related to ownership of these works. And one of the most recent was around the Stability AI being sued, the type of training data that they had seen. So another major question arises is that since to train any AI software, a lot of training data is required, which needs to be sourced from multiple channels. Now, would people who are helping you source the data, or if by mistake you have infringed the data of someone, you have captured it, without them knowing about it, used it as a training material, would they have any rights on the AI so created? Shailendra, you want to go ahead first for this?
Yeah, so of course, I think just again taking the ChatGPT example, the terms of use are very clear that you have to abide by the applicable law. You can't have a certain input which violates someone else's copyright or say other IP. So I think those laws would remain constant. And when you talk about stability, I think you're referring to the Getty Images issue, right?
Yes.
I think the output had the Getty Images watermark on it. And that was a clear violation, I would say, that you certainly can't take something, have a watermark, and in the output also you get a watermark which has the source in it. So I would err on the side of the conservative view that obviously you can't do that.
Even I agree with Shailendra completely. I mean, there would not be a better case for an infringement than using somebody else's watermark on the images.
And the thing is that, see, again, not to caveat like a typical lawyer, but these are all traditional views. We don't know what's going to happen in future, because there's a lot of chat as to how things are going to pan out in future and whether there needs to be a change in law. Like I think how Hemant brilliantly explained about the authorship and the ownership. You imagine you have other sets of dependent clauses within the Copyright Act, that work done in the course of employment. Imagine someone purchasing a certain AI software, asking that AI software to do something for the company. Who would be the author again? Whether it is in the course of employment, whether the machine or that AI piece is an employee, is a consultant. I don't know. There are several things which open up if you have to actually consider AI as the co-author.
Correct. And this also is very similar. Like, although we are discussing AI, like it sort of deviates from it, but like it is very similar to that entire copyright issue of the monkey picture that happened in US. And I think there also the courts were with the similar view that at the end of the day, whoever owns the copyright needs to be a natural person. You cannot you cannot pass over your rights to someone who is not a juristic person, or like having no legal right. So I think that also falls in the similar jurisprudence, similar trend that has been followed in US.
I think, as I said, that Mr. Sahni's registration has changed certain things. It's a good thing if it's futuristic, but it's just not in line with the jurisprudence which we have from the case laws.
Right. Because even like, if you remember, we were having that discussion, you brought out a very interesting point that if tomorrow we start giving rights to AI created content, and if say there is an infringement or there is any issue, like that will come, like, it becomes a very good defense that, it was created by AI. I have nothing to do with it. And, in the, like, just by hiding through that veil, like, you can do whatever you want to, and you will always have an escape, because how can you punish an AI? You can just say that, okay, I'll just shut you off. You cannot create any more content or something like that. So yeah. Interesting. And also, like, just to an extension to this, like, do you think Indian laws are well equipped to handle these kind of disputes that are that are coming in? Are there any such disputes that have come into India similar to these, like the stability AI that we were discussing?
Hemant, you want to take this?
As of now, I'm not aware of anything similar regarding like use of copyrighted work through an AI. The only dispute which Shailendra mentioned, that Sahni's dispute, where the co-authorship was questioned before the Copyright Office. The funny part is the manual of Copyright Office, in fact, clearly mentions, which actually the contrary to what they acted upon. So it mentions that the author has to be a natural person, which is consistent with the judicial precedents in the courts in India since last several decades, I would say.
Oh, interesting. Shailendra, you want to add anything to this?
No. So even recently, we've got an objection to that effect. This was a transferred case to us, and the applicant had filed the application on their through their in-house means, and they had named the company as author. And it was clearly, the objection was that you can't have the company as author because it has to be a natural person. So I don't know how it passed this thing. I'm not privy to what happened at the Copyright Office, but we've seen the kind of objections we have seen are in line with the jurisprudence which is said.
So I think that would, like, with the course of time, with more AI, like more content getting generated through AI, as and when it will keep happening, and more applications would go to the Copyright Office, I'm assuming then there will be a clear benchmark as to what needs to be done with the process. Because right now what it sees, like what we're able to see is that at one point they are allowing certain people to own the co-authorship, and at certain times they're not allowing it to do that. So I think with more cases coming up like that, more applications of that sort going to the Copyright Office, probably they might have a clear benchmark or like a clear practice or guidelines for their the examiners.
I think the balance line, probably, if we have to draw a balance line between the two, I think, and that's something which even other jurisdictions have taken a view, that it can't be merely AI as the author. There has to be a human intervention, and when it says human intervention, then there has to be a co-authorship between AI and the actual natural person. That is what has also happened in Mr. Sahni's case. where you have both the names included as the author. So it's not merely the AI which is the author. You have Mr. Sahni's name and you also have the AI as the thing. So probably that's the future. I don't know. And I think government is also looking into these things. So probably there's something which comes out of this, because there is also a possibility that the output which comes out, although the input may be something which is known, the output may be something completely different from the input, because it's an aggregation of whatever has been inputted in the system, which eventually gives out a completely different output, which is not a substantial reproduction, which is the key word when it comes to copyright infringement. It should not be a substantial reproduction of the original work.
Correct.
I concur with. I'm sorry to interrupt. So
please go ahead.
Add one thing here. So I think the way to, even I agree with Shailendra that generally what is happening is that AI is being added as a co-author in the application. I think there are reasons to do that, because as we just discussed some time back, that there has to be contractual obligations and there has to be like a legal capacity for an AI. So tomorrow if something happens, any liability arises, then in that case somebody has to be held liable in such cases. So therefore I think I would say probably a good way to go about is to allow co-authorship of an AI, where a natural person can be held liable for the actions of AI. Ultimately, it is a natural person who has created the AI. Be that as it may, the data that has been taken, that may have been compiled from different sources, but ultimately it is a human mind which is going behind creation of the AI. So there has to be, I would say, a line has to be drawn where we have to stop. And obviously the AIs are here to assist us, but somebody has to take the blame at the end of the day.
Correct. That is very aptly put. And I think, I sort of agree with this viewpoint that, as long as you have a normal human person along with AI, at least you have someone to blame for, or like at least someone is taking onus, or someone you can go after in case there is any infringement. Because for any system, like, it becomes very easy for them to shift the ownership on, or to it becomes very easy for them to shift the blame on. That makes sense. And I think in 2018 or 19, I think the government of India did plan on creating, like, they put out certain guidelines or something of that sort, asking a lot of ministries to look at how, like, because the AI was at the peak at that point of time. Now it is again is talk of the town. So I think at that time also they have instructed certain offices to look into it, that how the ownership of the AI can work in different places and stuff like that. So, but I think nothing has happened concrete in that direction. It's still pending, or like nothing has happened to that database as far as I remember.
So,
and I think, please go on.
Please go ahead.
No, please go on.
So I was saying, as far as the government developments are concerned, what I'm aware of is there is a standing committee report which was placed before the Rajya Sabha, that is a 161st report, where they have recognized and they have identified that AI is a sector which may not be governed separately, like in the sense that it may require a special set of like sui generis system for governing those legislation. And even there is it is identified that even the patent and the copyright law needs like an amendment in order to be consistent with the especially the AI generated technologies. So, I mean, after that, I don't see there is any development, but I think the discussions are in the, I would say, in the right direction.
I think, imagine this, right? That here at one breath, you want the AI to be the author. But tomorrow, if there's an infringement, as Hemant rightly said, you can't be filing a suit against the AI machine as such, or the AI system. You would eventually need a natural person. So it can't work both ways, right? There has to be some human intervention when it also comes to taking the blame for it.
Correct. Plus, I think even in Contract Act also, people would have to make certain modifications. I mean, the government would have to make certain modifications, because like for anyone to even assign a work, they have to be a major of sound mind and all of that. So I think if those kind of modifications or like those kind of amendments come into the picture, I think many laws will have to be changed.
Yeah.
But I think we'll have to wait and see how things develop. Correct. So another question that we had, this is a query that we have, received from one of the user that was coming in, like what is the interplay of IP and data privacy in these AI generated content? Like this is one of the questions that one of our listener had asked us previously. Like if we can ask it to you, it will be great. So Hemant, you want to pick this up first?
Sure. So as far as data is concerned, so ideally in these AI technologies, the data is the heart and soul of what is basically the training data that is being that has been taken for developing the AI. That is the heart and soul of the data. Now, what happens is a lot of times we may not realize we are disclosing personal data or sensitive personal data when we are inputting certain information. Like for example, be it when you are at a mall, you are using a device, or you're accessing the mall map, for example. You may be inputting your phone number, or you may be inputting your email ID, for example. So in such cases, there may be an overlap where a personal information or a sensitive personal information may be compromised, and it may have been obtained by not taking your explicit consent, which is now, I would say, in the future laws, it is going to be there. It may not be like explicitly, like I would say, covered in the present legislation, but yes, in the future, the pending bill that is there in the parliament, the explicit consent is something that has to be there when you are talking about the data privacy aspect, when you're collecting a personal information or sensitive personal information. So there has to be like a framework has to be developed where we are able to protect the sensitive information and personal information from being compromised while AI is being developed. So that aspect has to be considered from these lines of argument.
Understood. Shailendra, you want to add something?
Yeah, so not an expert in data protection, but whatever knowledge I've gained from my specialized team is that, see, there are two ways where this could go wrong. One is from the system owner side, the software owner side, where they probably make it very clear that, okay, we are abiding by the data protection laws by, say, anonymizing the data, so on and so forth. But the second aspect is where the user tries to include an input, which also includes personal or sensitive information, which is very difficult to track. Now, if that goes into the learning of, say, through the machine learning process or through the AI process, there is not much which the system owner or the software owner can do, because eventually it will pick up that data as part of the input data, and that is likely to create certain issues. So two aspects to be considered. One is from the owner's side, the system owner, the software owner's side, where all your privacy policies, etc., would be very clear. Like I think ChatGPT also has a proper policy there as to how they go about things. But I don't have an answer if the user tries to include certain data or input certain data within the machine, which catches up and which picks up certain sensitive information. What happens to that? I don't have an answer to that, to be very honest. It will lead to a violation, and there has to be a certain framework towards it.
Understood. This is very interesting take, because recently, I think I was reading on LinkedIn only that Allen and Overy have adopted one of the they've created a tool. They were trying it out for a while, and they've recently introduced it to at the conceptual level at their firm, and now they're exploring if it goes well. Like it obviously they wouldn't use it for all the clients, but they're saying that we will take the prior permission of our clients and then we will use it. So I think that is where the play comes in, that you before doing anything, before training the system or before putting it any information in the system, like the prior information of the prior consent of the person whose content you're going to put in becomes extremely important. So I think this would be the trend going forward.
I think, and when it comes to the legal tech, it is very important that merely consent is not the only thing which needs to be considered. If you're using a certain draft, there has to be a prior redaction of it, because it's not merely the names and addresses or the contact details which matter. There will be certain commercial aspects as well, which will have to be redacted before that document gets into the system, because you don't want a situation where suddenly a clause is picked up from an agreement and it is thrown up as part of the output, and it gives out the entire commercials of it.
Absolutely.
That would be a big mess, I'm sure. No, that is correct. But do you have like any information? Like recently, India is working on their, data privacy acts. A lot of work is being done. There was a bill that was introduced, then it was called back. Then again, there's work of a new bill. Like, do you think that these kind of things are also getting incorporated in the bill, or like it's still staying silent on these kind of issues? Do you have any idea about this?
Well, I wouldn't like to comment right now because I think it's still evolving. But
Okay.
certainly these aspects would come as part of it. And I think it's an evolving process because out of nowhere, ChatGPT came in and suddenly people are onto it now. You had the NFT metaverse era where everyone was talking about it. Now suddenly it is ChatGPT. So I think it's best to wait and watch and see how it evolves. Unless Hemant has any views on it.
I think it's too early to comment on it. I think once an act comes into place and then we have the practical experience of dealing with these issues, then I think we'll be able to comment better on that.
Understood. It's just that because like right now, if in case a new law is coming in, it needs to be comprehensive. So it would be interesting to see. Like I completely agree that, since nothing has been passed as of yet, there's no concrete act as of now. So it would be interesting to see that, if they are able to capture all these information, because if they have, that would be a very well thought of, well created act, made with keeping future in mind. So that would be very interesting to watch out for. Great. So I think these were the pretty much the questions that we wanted to discuss initially, but we have a lot of participants. What we'll do is we'll open the floor for our the listeners, whoever has joined in, and in case they have any questions, let us pick them up.
This will be a difficult one.
In case anyone is having any query, you want to ask anything from our experts, please feel free to put in the chat, and we'll try to answer as much as possible. So one person has put a question, which is, what will be the liability of the creator of the algorithm which powers the AI? Anyone?
Hemant, you want to take it up? Or probably.
Sure. So as far as the ultimately, as on today, if I'm talking about the liability, it is going to be on the author, who is the owner of the work as well, unless it is assigned by an agreement. So the liability will not be with the AI. So whatever, as on what we are, the law as it stands today, if any act of violation is taking place through an AI, then the liability will accrue to the author itself or the owner itself of the work.
I think probably it's as Hemant said, it will be the person who actually inputs some data which is in violation of a third party right. Now, probably say in case of OpenAI, which runs ChatGPT, they haven't disclosed their source as of now. So in such a case, it's very difficult as to who is actually including it in the system. But if you're able to pinpoint that someone has used certain content which is in violation of a third party right, I think that person will be liable, and the system owner or the AI software owner may have certain immunities like you have for, say, intermediaries, etc.
So this is very similar to like Stability AI, like whoever has created Stability AI is getting sued primarily because they have sort of like, it's very easy to prove that, they've taken the images of Getty and then, they are being tried.
Yeah. So contributory infringement, probably the AI owner would also be, as a matter of strategy. See, now again, things have changed over the years. Earlier, domain name registrants had a certain immunity and they were not included within the litigation system as such. But now increasingly you see the Delhi High Court going after the likes of GoDaddy and other registrars, saying that you need to have a certain diligence and you just can't say that, okay, this is not our responsibility to look into it. So a certain amount of due diligence would be required. Now in case of Stability AI especially, because if you're going to take the source as Getty Images and throw up certain things which have the watermark, then obviously they would be responsible and not probably someone who's an input holder. There are flurry of questions coming in. I think probably.
but I think this also brings in a very interesting question. Like, like I was in the intro, I was saying that, now people have started using these AI powered tools at their work. Now, a lot of times they may not be with the consent of their employer, but, the problem will also arise, like in case, say, a person has been employed by some organization and that person uses AI without the knowledge of employer and creates a content, and that in turn ends up infringing some other content. So like in that situation, who do you think would be the violator? Like it would be the employee or the employer? How would the situation be like?
Obviously, I think the employer would be first taken to task by the owner of the work. But eventually there will be a back-to-back arrangement with the employee where you have those employee contracts stating that you won't violate a third-party intellectual property, and you would probably indemnify the company if you do so. Now, those would be triggered, those contracts would be triggered, but on the face of it, it would be the employer, I would say. Because eventually the employer is responsible for what the employee does within the realm of the employment.
So I think that would make the task of the employer extremely difficult, because now they just not have to check like the quality of the work, but they also have to check that whether it has been sourced from some AI or not.
you forget about this. We have recent cases where copyright societies have gone on YouTube and recorded certain reunion videos or alumni videos where certain songs were being played and no permission was sought. And the employer has eventually been named in the police complaint, saying that it was your team which was playing this song as probably part of the reunion or whatever was being arranged, and that's why you guys are responsible for it.
Wow, that is one really interesting case. Great. So there's one very interesting point by Tanmay. He's mentioning that should there be a consent framework for the training material being used for any AI or ML model? For example, should there be an option for people or entities to opt out from using their content as training material for the AI ML model? I think this absolutely makes sense in terms of the data privacy, in terms of the type of learning that you make, because as long as you have a framework where you have explicitly given the consent, everyone would be able to win. Like it would be a win-win situation, because the AI ML model creator would get the content from, like where they've gotten the explicit consent, and at the same time there will be no like any issues related to data privacy as well, because the consent has been received. So I think this would make more sense to have a framework like that. What is your opinion on this, Sharif?
Yeah, I think so. You see, obviously, if a consent is sought, that is the best way to go forward. No one should use anything without consent. So that is clear. And if the consent is withheld, then obviously no one can use that as part of the system as such. I'm sorry if I didn't answer the correct question, but
No, I agree with Shailendra that consent is something that is important. I believe even Stability AI had actually come up with the opt-out policy for the artists. So it had invited artists to opt out of their systems. So that is, I would say, in line with, I would say, a fair play. And I think that would make sense in order to avoid infringing work being like rolled out on the platforms as a training data.
Right. Absolutely. And I mean, yes, because even like we all are agreeing that, as long as there are proper frameworks where people have an option to opt in, opt out, like that would make more sense, for everyone. Great. So we have another question from Isha. She's asking that, we were discussing about the copyright ownership of, the advocate Sahni's work, the application. So her question is that on the liability of such co-ownership when it comes to infringement, because in case of joint ownership, one owner can't even license or transfer the right without others' consent. So can AI actually give consents to its co-owner? So I think it's exactly what we were discussing. You would like to elaborate again once on that?
Yeah, so there'll have to be a human intervention eventually, because the machine obviously has to be directed to do certain things. And that direction would would come from a human intervention. So, and it will be the human who gives that consent.
Correct. And plus it would depend, like, the terms and conditions, like the policies or the terms and conditions of that AI generated tool as well, in case, like the ChatGPT that we were also discussing, that in case they've explicitly mentioned that the input holder, like all the copyrights would vest with the input holder and they would be liable to whatever that has happened in that situation. Like they have at least, put their hands clean, and the onus lies on the owner or like the creator of that content as to what needs to be done. Hemant, you want to add anything to this?
I agree with this. I mean, there has to be a human intervention in this because you can't just like make an AI liable. What will the AI do at the end of the day? He's not going to pay you compensation. Either he's going to restrain himself from using the work. So there has to be an intervention, like a human intervention involved in order to, like, I would say, do the justice in an infringement action.
Correct. There is another question where Siri has asked, what about the right to monetize the copyrighted material? If AI is recognized as a co-author, will the right also rest only with the natural person? Hemant, you want to pick this up?
So again, like AI will lack the legal capacity to contract out the work. So in that case, I would say you will have difficulties in contracting out the licensing out the work to other people for commercializing.
Correct. Shalin, you want to add something to this also?
No, I concur with because I think without the contractual elements being satisfied, no one would be in a position to contract out any monetization as such.
Understood. Let me see if we have any more questions. There is one. So Dhruvi has asked, how will this copyright on content created by AI affect the professionals? As we can see that the content that is given out is what people who are not aware about the field easily trust. So this is very similar to like what we were discussing was on the employee-employer relationship. This is more to do with, if the professional has created or like they've used AI, created a tool which later on ends up infringing, given it to the person who is contracted. I think the similar situation would arise, like, just what was the situation with the employer-employee relationship, or would it be different?
Yeah, I think it'll be the same thing, because say right now even I think Delhi High Court has made a observation on usage of Wikipedia that you can't rely on. You put it on the similar lines, that it is a database which is not reliable as such, and you again need to go back to the terms of usage. There'll be a whole lot of disclaimers which the AI software owner would have put up there, that there's no liability which is considered, and they disclaim everything which comes out of it, and you're doing it on as is where is basis. So to that extent, I think you need to go back to the terms of usage and see whether there's any certainty to the data or the output which is being thrown out.
Correct. Great. So I think these are pretty much the questions that we have received. So this is pretty much it. In case there are no more questions, I think we'll end the webinar. It was lovely hosting you, Shailendra, Hemant. It was really insightful. I'm hoping that, everyone who was attending, they were able to get something out of this, because usage of AI in general, we're talking so much about ChatGPT, but I mean, usage of all these AI tools, they're increasing manifold, over the course of time, and it is bound to increase. And, having a proper understanding of the laws around it obviously helps, because you know what you're getting into when you're using it, or how, you have your way around, while using these kind of tools. So definitely this was helpful. Thank you so much for taking time out as well from your busy schedules. I understand it was very difficult to get you both on the same time. You're running on a very busy schedule. So thank you once again, for joining in.